All right, everyone, it is just now 12 o'clock, so we're going to go ahead and get started. Welcome to all, and thank you so much for joining us for our 24th annual Virtual Elder Abuse Conference, Evolving Interventions and Resources. This conference is presented by Caring Transitions of Syracuse, and my name is Lauren Ulrich, and I am the Abuse and Later Life Prevention and Outreach Coordinator for Vera House. All webinars offered during this conference are free thanks to the generous support of our sponsors. And this year, in addition to our presenting sponsor, we have 3 platinum sponsors, and those are Onondaga County Department of Adult and Long-Term Care Services, Loretto, and Syracuse Jewish Family Service. I'd also like to acknowledge our gold sponsor, Wegmans, and our silver sponsors, At Home Independent Living, Bousquet Holstein PLLC, Community Bank, Christopher Community Incorporated, Countryside Federal Credit Union, Fulton Savings Bank, Geddes Federal Savings and Loan Association, the Marone Law Firm, and Touching Hearts at Home. And just as a reminder, more information about all of our sponsors can be found on the Vera House website at the virtual resource table, and the link to that virtual table can be found on the conference registration page. The support of these sponsors not only funds this webinar series, but also extends beyond our conference to continue vital elder abuse education, outreach, and prevention work after this event. And just a final announcement before we begin, the chat feature in this webinar has been disabled, but you are welcome to submit questions to our presenter via the Q&A feature. And I'll be monitoring that Q&A throughout, and also if time allows, there will hopefully be some time for additional questions at the end. So without further ado, I am very honored to be able to introduce today's session, Power of Attorney, Statutory Changes, and the Potential for Abuse. And it's my pleasure to introduce you all to today's presenter, Morgan Thurston. Morgan is the Assistant Welfare Attorney with the Onondaga County Department of Law. So Morgan, I will now turn it over to you to introduce yourself and to begin today's session.
Well, good afternoon. Thanks for having me. I've been presenting with this conference for I think this is probably the 16th year that I've done a presentation. This year, we're going to talk about powers of attorney and a lot of the recent changes. I'm going to go ahead and share my screen and we'll work through my PowerPoint. So again, the title, Power of Attorney 2021 Statutory Changes and Potential for Abuse. There's a lot of changes. Before I get into really the changes, I just want to spend a moment talking about powers of attorney in general. They're one of the most misunderstood documents, I think, in both purpose and what their scope is. Power of attorney is an instrument which delegates to another person authority to really just make financial decisions. It does not grant any authority to make medical decisions. That would be a healthcare proxy or Family Healthcare Decision Act, but nothing for under the power of attorney gives the ability to make medical decisions. And the change, there is something called a statutory short form power of attorney, and then other items that are not statutory, they're non-statutory powers of attorney, but they're adding that definition in starting this year, or including non-statutory powers of attorney for acceptance. But so it's a document that you're delegating your authority to someone else to act on your behalf, and it concerns financial matters. It can be effective when you sign it, and it's not just your signature, but it's also going to be the signature of the person acting on your behalf. One of the most misunderstood things with powers of attorney is that, and I do this all the time myself, is that when you have a power of attorney, you call yourself the power of attorney for someone else. Well, you're not the power of attorney for that other person. You're their agent or their attorney in fact. And they've actually, the new statute, the changes are making it clearer how you're supposed to sign as agent or attorney in fact, you don't sign as power of attorney. And the power of attorney, you can make it effective at a later date or upon a certain occurrence of an event. Most times I technically don't use those, or typically don't, from the standpoint if you're trying to rely on a particular event, maybe a doctor saying that you no longer have capacity, trying to get that physician to sign off on that document can be very difficult. So most power of attorney we're looking at are effective when they're signed. The person may not be using them, but at a minimum or as a requirement, when you pass away, the power of attorney passes away as well. It's no longer effective once the person that has the principal has signed it or has passed away, it ends. This slide I also put on there guardianship. There is a big difference. Power of attorney is where you're authorizing someone else to make decisions on your behalf. Guardianship is where a court grants powers to someone else to act on your behalf. And in New York, it can be limited, it can be general, but it also requires a finding that you lack capacity and that you're in need of the guardian. So different where you have a power of attorney, you're acting, you're making that choice. Guardianship is a court imposing it upon you. All right. So that's generally what a power of attorney is. Big changes effective June 13th, 2021. So that just happened last week. However, to be mindful, the power of attorney, if you had executed, validly executed prior to June 13th, will remain valid. There's not an obligation that you need to go out and get a new power of attorney. One question, a recent presentation I was doing, question was, under what standards would your old power of attorney be looked at? And best guess on that is that the old standards, which to be a validly executed power of attorney prior to June 13th, it had to be exactly conforming to the language that the state has provided. A big change for this year is substantially conforming. I have a slide on that next, but again, your older power of attorney, you don't have to run out. There's going to be some learning curves with these new power of attorney and financial institutions accepting them, and financial institutions continue to accept older powers of attorney. It always happens. That's why for some of my private clients, I've been waiting until the new statute kicked in just to avoid any potential issues with a financial institution, just to make it clear it's the new form. So that's effective June 13th. So the statutory short form, the statute actually puts out the form. You can turn to the general obligations law in New York State and you can look at the form. And you will, the change here though is the use of the following form. So they dictate what the form is going to be, or one which substantially conforms to the following form. So that's the problem, or one of the issues that we're looking at, is what does substantially conform mean? How are the courts going to have to define that? What is it? I have a guess of what it means. I just don't know where it's going to fall and what's going to be the issues, because talking with other attorneys, these changes were really, the New York State Bar Association was a big proponent of the changes. And actually financial institutions also lobbied for these changes too. But this is a major change because they felt that requiring people to exactly conform had created some situations where powers of attorney that probably should have been honored were not being honored. I just don't know where this is going to go. And our fear, working with elder abuse and we're going to spend some time talking about special proceedings on people that are potentially abusing power of attorney, is this going to give them another avenue to potentially abuse the form or have a form that might be confusing to the person signing it that's still valid? We don't know. And is this going to create a lot of court activity? It's brand new, so we shall see. But that's substantially conform. That's a big deal. That's a big change. Another one, they've labeled certain things as optional in the statute. And if you're not using the optional clauses, then you can omit them and replace them with the words intentionally omitted. I don't know. I'm going to see how this works out too with the intentionally omitted, if people are going to use it or not use it. And it was included to help reduce the length of the document, because it is long. I can't remember, I signed one yesterday with a client and it was over 10 pages, but gift transactions. This was a huge change. So prior to this change, I'm going to go back to that slide we were just on. I want to go to this one first. Under the prior to June 13th, you had to have a secondary document if you wanted to make gifts over $500 in a calendar year total. So we had something called a statutory gift writer. This is from 2009, September of 2009. It was modified in 2010, but you had to have the secondary document. That's been repealed. There is no longer a statutory gift writer as of June 13th. But so going back, what did that do to gifting? Well, we no longer have a separate gift writer. Now what we have is, if you want, in order to authorize your agent to make gifts in excess of an annual total of $5,000. So it's been raised from $500 to $5,000. So for all gifts described in the grant of authority section, or to make changes to interest in your property, must expressly grant that authorization in the modification section below. And in addition, if you wish to authorize your agent to make gifts to himself or herself, he must expressly grant such authorization in the modification section. And then the cautionary thing is, it does say granting such authority to your agent gives your agent authority to take actions which could significantly reduce your property and or change how your property is distributed at your death. You should discuss this with a lawyer. So they put that into the statute. So now if you want to gift over $5,000, you have to add that in the modification section. You're going to initial that you want to gift. And then if you want to gift, if you want the agent to be able to make gifts to themselves, and for a lot of my clients, they do. The scenario being, a lot of it's put in for Medicaid type planning. If you had a client that had whatever the size of their estate, if they had a stroke or some other medical emergency and they end up in a nursing home, it's going to be permanently placed in a nursing home. They're looking at a Medicaid application down the road. Prior to qualifying for Medicaid, they going to have to spend their assets down till they reach the Medicaid levels. There is a planning technique that's perfectly legal, and it involves gifting, and it involves doing a promissory note. So you could potentially protect about 50% of your assets that you worked hard to obtain. So for that process, you need to be able to make gifts. And for most of the clients I deal with, they would want to include the agent too, which for most clients, it's one of their children. So making the gifts and including it can be an important tool, and it can further what the goals of the client are. And for most of my clients, what they want to do is they want to see their family members get their assets that they worked hard for. That's the way it's designed. That's the way it should work. However, what we run across in my role with the county and representing Adult Protective is we see people abuse it. And we see abuse of the gifting authority too. If they're granted the ability to gift, they could potentially gift it to themselves. What the requirements of the power of attorney statute say, though, is that they have to follow the wishes of the principal, if it was their parent or whoever signed the power of attorney. And if they don't know the wishes, they have to act in the person's best interest. So even if you're making gifts, you have to follow their wishes or in their best interest. Now, if mom or dad signed a will that said, I want to split amongst my 5 children, and the one person acting under the power of attorney, the agent, then gives all the money to themselves, did they follow the wishes? There has been at least one court case that I've seen that they said, no, that you're not following the wishes of the principal. So, but this is a huge change. No more statutory gift writer, but it can be included in the modifications. We raised it from 500 to 5,000. The other thing that I am less comfortable with, the form I'm using, is that you specifically initial the types of gifts you want to make. you don't necessarily have to do that. You can initial one point where you say you want them to make gifts, and then it could be maybe not as clear, and that could be a potential for misdealing too. So we talked about the gift writer being reformed. Some changes with the signing of the power of attorney too. So the power of attorney is supposed to be signed, initialed, and dated by a principal with capacity, or in the name of such principal by another person. So this is a change. We're now allowing the power of attorney to be signed by someone else on behalf of the principal. And the person signing on their behalf can't be the principal's agent or a successor agent. So the person that's going to be acting cannot be the person acting as the person sign. They cannot sign on behalf of the other person. And then the manner that needs to be signed, it's the same way that we're going to transfer real property. And it just gives some direction on when the person signs at the direction of the principal, he or she shall sign by writing or printing the principal's name and printing and signing his or her own name. So there's clear directions on what you're supposed to do if you're signing on behalf of someone else. But that's a change. That someone that may physically be unable to sign on their own can have someone do it at their direction. The other part, though, is that the person does have to have capacity to do the signing, but physically they can't accomplish it.
Just a quick question in the Q&A, Morgan.
Sure.
Someone is asking, does this change apply to those with or without capacity?
Could you say that again, Lauren?
Oh, sure. Someone was asking, does this change apply to those with or without capacity?
Well, it's only, there was never an ability to sign a power of attorney if you didn't have capacity. So it's only applying to people with capacity. So it's just made it clearer that you had to have capacity to be able to sign a power of attorney. So that's only applies there to people with capacity. I'm going to go over the definition, the statutory definition of capacity in just a couple slides too. The other interesting thing that they talk about is what does sign mean? It means to place any memorandum, mark, or sign written, printed, stamped, photographed, engraved, or otherwise upon an instrument or writing, or to use an electronic signature. This becomes very interesting too, is it probably more with COVID is people trying to sign remotely and using electronic signatures more on like real estate contracts. We are seeing that. One thing though, it says in accordance with requirements of the technology law, a power of attorney or any other instrument executed by a principal or agent that is recordable under the real property law shall not be executed with electronic signature. Well, pretty much anything that a principal or agent could do could be recorded. So that's a tricky area, whether electronic signatures are going to work or stamps. It's there. It's in the statutory definition. I will just say, as a practitioner, I'm going to do everything I can avoid to use any signing other than the person signing or pursuant to what the statute having someone else sign on their behalf. I wanted to point that out.
Great, thank you. We just have one other question about signatures, if that's okay. Someone asked, if we do not have a principal to sign it, can it be a hospital staff or another worker?
Well, again, it's the principal can direct someone, as long as the principal has capacity and they're not able, they can request someone else to sign on their behalf. It could be a hospital employee. The only two people that the statute says can't sign on their behalf are the agent or a successor agent. So the person you're appointing to act on your behalf cannot do it, or their successor can, but someone at a medical facility could. Another change, witness requirement. The statutory gift writer had a requirement that you needed 2 witnesses to sign, but the power of attorney itself did not. They got rid of the statutory gift writer, but they added the witness requirement into the power of attorney itself. So now the power of attorney is going to be signed in front of a notary and also 2 witnesses. So that, again, that shouldn't, witnesses, we should have someone that's going to be independent too. The notary can be one of the witnesses. So that's, I signed one yesterday. I acted in both capacity as notary and as a witness, and that's fine.
Another question along these lines, Morgan, thanks for addressing all these. We really appreciate it. Someone commented that it seems problematic that the person would not be directly signing the document, that someone could be signing on their behalf. And the question is, how do we know they were involved in the decision, specifically if technology is involved?
Well, yeah, I mean, if it's just technology, but the precautions are there. I mean, it's still going to be notarized. It's still going to be at the direction. The person's still going to be there. But someone else is signing on their behalf. Now with the electronic signatures, again, if it's someone else signing on their behalf, I'm going to be, that's going to be very scary if they try to combine electronic signature remote without the person, because again, it's signing at the request of the principal there. Okay, so in notarizing that. So it's new, but I understand why they're adding this in, is to give people that didn't have the physical capabilities to sign the ability to, even if they have capacity, direct someone else to sign on their behalf, so they could have a power of attorney. The benefits of what a power of attorney brings to someone. Changes to acceptance. So if you present a power of attorney to a financial institution, they now really get 10 days to accept it or actually reject it. They can honor the statutory form within 10 days or reject it in a writing that sets forth the reasons for rejecting it. And the statute does spell out certain reasons, valid reasons to reject the power of attorney. One change in addition into the acceptance proceeding is if you bring, there's a special proceeding that can be brought. I'm going to talk about that more, about my role from adult protective and why we bring special proceedings. But if a special proceeding is authorized and brought to compel a third party to honor the statutory power of attorney, in the past, prior to the new statute, all they could do was compel the person to accept it, a bank or whatever. That's all they could do. Now with the new statute, it says the court may award damages, including reasonable attorney's fees and costs if the court finds that the third party acted unreasonably in refusing to honor the agent's authority under the statutory short form power of attorney. So not just compel, you can get damages.
We have two more questions regarding signatures. Maureen, this seems to be two of the same question. How can you do an electronic signature if the signature has to be notarized? Two different participants asked that question.
There is, you'll have to look at the statute, but there is a way to remotely sign and electronically sign. I can't tell you how this is going to work in theory, but you can see the statute. I just copied the language from the statute. Sign means a place or to use an electronic signature. That term is defined. The one thing they did say is a power of attorney or any other instrument executed by the principal that is recordable under real property law shall not be executed with an electronic signature. Now, the power of attorney document itself is recordable. So that's a confusion in the statute. And I have heard one attorney say that based on that, they should never have an electronic signature. I'm not so clear on that you would never be able to do it. I'm going to say, I don't envision a scenario where you ever would want to. And I'm not going to be the person figuring that out. So I'm sorry if that's not the answer, but it is confusing. That's why I wanted to put it out there and make sure people were aware that that's a change into the statute as well. I said I'd mention capacity. So this is it from the statutory definition for powers of attorney. The ability to comprehend the nature and consequences of the act of executing and granting, revoking, amending, or modifying a power of attorney, any provision in a power of attorney, or the authority of a person to act as an agent under a power of attorney. So when we talked about someone with capacity, this is what we were talking about. And this is what the standard that we're looking for if someone is going to sign a power of attorney. And the public policy is we want people to be able to sign these documents. They are important documents. There are problems with power of attorney. They have been abused, but I still recommend my personal clients that they have them. Because if you have a medical event without a power of attorney, you may be looking at a guardianship. And someone could step in and act on your behalf without the need to go to court, without the need to spend potentially thousands of dollars to try and become your guardian. So that's why I think they're important, and why there is a public policy that we want people to be able to sign them. And this is who's making this determination. I certainly, as an attorney, when I'm signing with someone, I'm kind of making this determination. If I feel that they don't understand the process, they're not able to understand what we're signing or follow the conversation or direct me on what they want done with their power of attorney, then I may make the determination that I'm not going to be a witness. I'm not going to be the notary either. So that's the language. Another common misconception about powers of attorney is the authority to revoke. Once you sign a power of attorney, you haven't given up your rights. You give up only way you give up your rights is if a court determines you lack capacity. But if you sign a power of attorney and it's a statutory durable power of attorney, that it's still in effect if you become disabled. So it can assist you if you do have a disabling event. However, just by signing the document, you're not giving up your ability to act on your own. You're not giving up your ability to revoke the power of attorney, amend the power of attorney. So you still maintain that right. That is a common misconception, though, that they feel like it gave power of attorney to this person, I can't make that decision anymore. So how do they revoke? Principally revoke a power of attorney by, two bys there, delivering a revocation of the power of attorney to the agent in person, or by sending a signed and dated revocation by mail, courier, electronic transmission, or facsimile to the agent's last known address. If recorded, the revocation should also be recorded. So if you record your power of attorney with the county clerk, you should also record any revocation. And termination of the agent's authority is not effective as to any third party who has not received actual notice of the termination and acts in good faith under the power of attorney. So if you revoke it, but you don't tell the third party bank that it's been revoked and they still continue to honor it, it's not going to be their fault.
Morgan, we have a question in the chat regarding the capacity determination. There's another question as well, but I think this one might be a better question to save till the end. So for the person who asked that, I do see it, and I'm going to reserve that for the end. Regarding the capacity question, the question is, for capacity determination, can a lawyer have a different opinion from a doctor on the person's capacity to appoint an agent for a power of attorney?
Yes, absolutely. It's not there's difference between, and I've done a lot of presentations on capacity, competency, and is there a difference? Is it competency to make a medical decision, capacity being a legal determination? Technically, courts are the ones that will determine if you lack capacity. But again, and ultimately the court can determine that in a special proceeding too, make a determination as to whether the person actually did have capacity or not. But someone could be diagnosed with dementia by a physician, and that does not mean that they lack capacity to sign a power of attorney. They could understand what they were doing, make the formal request, and the attorney could validly prepare and sign power of attorney for them. It's a total gray area, but for good reason. And ultimately, the determination on capacity and whether the attorney acted properly could be decided by the court in a special proceeding.
And And then just a quick clarifying question. Do powers of attorney have to be recorded, or is this just optional?
They don't have to be recorded. There's some, it costs money to record, so it can be expensive, especially making changes. But if you record it, you can get certified copies of the power of attorney. So if a financial institution wanted a certified copy, you could provide that at any point you needed to. These documents are complicated. Implementation has become more involved. There's major changes in 2009. I talked about the statutory gift writer. That made it even more complicated. So from 2009 to 2021, they've been complicated. One of the believed reasons for, or stated reasons to make these changes was to make it less complicated. I haven't found that to be the case. I don't think that the document is any less complicated. I think actually it might be even more complicated now to sign and to go through. It's just as long. Additions there's initials all over the place. It can be very easy to sign it wrong, in my opinion. And so I don't feel that it's any less complicated. I don't think that I understand some of the reasoning behind the new revisions, but they haven't made it less complicated in my opinion. Turning to the improper use of powers of attorney. For years and years, powers of attorney in New York State have been labeled a license to steal. This is, I think, the fourth major change to the power of attorney statute, maybe fifth, since I've been an attorney for these last 25 years. And powers of attorney were often called the license to steal. And they've made changes to try and make that process that happen less. And I think there have been improvements, and I will talk about some of those too. However, we still have problems. Many times, if someone abuses a power of attorney, we might run into a scenario where law enforcement may say, this is not a criminal matter, it's a civil matter. You've got a power of attorney, you need to go through civil court. However, if someone takes advantage of their authority and accesses the person's assets to their benefit, contrary to the wishes, or to their detriment, putting them at financial risk, it can be a criminal matter. It should not remain a license to steal. And there are some protections that continue. They didn't get rid of the special proceedings that we'll get into now. Again, I already said this, civil matter, a little recourse against the individual. When you're acting as an agent, you should observe the standard of care that a reasonably prudent person when you're dealing with a property of another person. So there is a standard of care. And I've said this before, when you're acting as an agent, you're supposed to follow any instructions from the principal, or if you don't have instructions, in their best interest. You're supposed to avoid conflicts of interest. So you shouldn't be doing something contrary to their interest. And again, making specific gifts to themselves. If you don't have authority to do that, you can't. As a fiduciary as well, you're supposed to keep you're required to keep the principal's property separate and distinct from any other property owned by the agent, except for property that is properly jointly owned by the principal and agent. Or with the new statute, or is converted into a jointly owned account with the principal agent pursuant to gifting authority. Again, if you make that gift, you're going to have to do it in the best interest of the client, or pursuant to the principal, or pursuant to their wishes. This is another one that's missed all the time. They have to keep a record of all receipts and disbursements. Then they're going to have to keep that record and make that record and the power of attorney available to the principal or to third parties at the request of the principal. So keeping an accounting is often overlooked. And I think prior to 2009, it was just mostly misunderstood. But since 2009, with the power of attorney is required to be signed by the agent. To be effective, they need to sign it in front of a notary as well. And part of that signing it, there's a page that explains exactly these powers I've gone over the last few pages, including keeping a record of all receipts and disbursements. So this goes back to that civil, this being just a civil matter or a license to steal. It's an easier prosecution now when you actually have the agent signing the document saying, I understand that I need to keep this separate. I understand I have to keep record of receipts and disbursements, and I have to act in their best interest. So that is an improvement since 2009. Keeping a record, keeping information that is inscribed on a tangible medium or that is stored in electronic or other medium and is retrievable in a perceivable form. That's a lot of words, but so they have to keep it so they can reproduce it and show it to someone. Keeping receipts, doing that accounting, it's an important job, and they should take it seriously and keep these records. So the other people, other than the principal, other people that can request the account, copy of receipts, and a copy of the document itself, a monitor can be appointed to observe their activities, co-agent or successor agent, government entity, that's where I would come in acting on behalf of Adult Protective Services. We can request it through Adult Protective, and we do. A court evaluator, that would be someone acting in a guardianship proceeding. The court evaluator acts as the eyes and ears of the court, and they can request a copy of the record. A guardian ad litem is a guardian at law that they're appointed for really one proceeding. If you were involved in an eviction and you lack capacity, or I've seen in divorces where the person being divorced lacks capacity, the court can appoint a guardian to represent their interests in that particular proceeding. They can get it, court-appointed guardian, conservator. We used to have conservators and committees. There's still probably some out there, not as many anymore, because it's now just guardian. And personal representative of the estate, that'd be the administrator or the appointed executor. So all those people can request this accounting. If the agent fails to provide the power of attorney or the accounting, within 15 days, the special proceeding can be commenced. And there's several remedies that can come from this special proceeding. One being determine whether the power of attorney is valid. Determine whether, this is where I said the judge can determine whether the principal had capacity when the power of attorney was executed. Determine whether it was obtained through duress, fraud, or undue influence. Determine whether they should get compensation or whether the compensation they received is reasonable for what they did on behalf of the principal. And can approve the record, this accounting of all the receipts, disbursements, and transactions. They could disprove it too, but they could remove the agent upon the grounds that the agent violated, is unfit, unable, or unwilling to perform the duties under the power of attorney. If we have multiple agents that are supposed to be acting together and they can't get along, the court can intervene and tell them how they're supposed to act. If there's an unclear or misinterpreted provision of a power of attorney, the court could intervene in that scenario as well. And they can compel the acceptance. And in which event the relief granted is limited to the order compelling acceptance. Actually, this slide, I missed this, I didn't update this. Now, it's one of the earlier slides, the court can award damages, including attorney's fees for not reasonably accepting the power of attorney. So this slide is changed. They can get damages against them. Who can bring the special proceeding? Agent, spouse, child or parent, principal, successor, and interests, those listed before. And it's not slide 10, and I didn't update that either. It's slide 24. Apologize for that mistake. And if the power, I think that's the right one. Yep. If power of attorney is suspended or revoked and the agent's removed, the court may require the agent to provide a record of all receipts, disbursements entered into the agent on behalf of the principal and deliver any property that they still have to a successor agent, a government entity, or the principal's legal representative. So it's not, you can be suspended, you can be revoked, but you still have to account. And if you don't, you could end up in a contempt proceeding. I did bring one contempt proceeding for someone that refused to account, and they were found in contempt. They're given the ability to purge their contempt. They didn't do that. It was found to be willful, and the person did go to jail under civil contempt. They were sentenced, I believe, for 90 days. They didn't serve the full 90 days, but they did have to go to jail for that.
Morgan, we have a question on this idea of receipts and accounting. So a participant asked, are receipts required if the power of attorney has a joint bank account with the principal?
So joint bank account is owned, joint bank accounts are tricky. So a lot of my clients that I talk to will establish a bank account jointly with a child. And what they need to understand is when they do that, they've given a gift to the other person, they can do whatever they want with those funds. And when the person established an account passes away, it's owned by the person that received it. That's a joint bank holder. And I have a lot of clients that set these up. And then I said, as long as you understand that upon your death, that child, they own that account, you're doing it with knowledge, you're doing it because you want to do it. And I've had a lot of clients say, but that child's going to do the right thing. They're going to share it with their siblings. And I say, they very well may. And I've had cases where they've done that, but they may not too. But no, if it's a joint bank account, you're not entering into it as an agent. I don't think that would fall under there. Now, if it was just done for convenience, there are things such as a convenience account in New York where you're not really a co-owner, but you were just on there for the convenience of writing, and you are also the power of attorney. I would make the argument if I was requesting it as in my role, representing adult protective, I'd want that included because what was done. Now you can make an objection, say I'm not going to account for that. It's not 100% clear there. I have a few cases I want to go through. Just I think we're doing all right on time. This is a case that with this presentation we did last year on power of attorney uses and abuses, a lower court actually said a half brother did not have standing to file a special proceeding. And the appellate division said, well, Supreme Court, you may have been right that in determining that, but that was never raised by the parties in the proceeding. And the parties had no opportunity to address that issue. So you can't just on your own make that determination, court. So they said, because that wasn't raised by any of the parties, you shouldn't have made that determination. So the case is being sent back for that reason to be heard. And the appellate division also found that the Supreme Court had made a mistake in dismissing the second cause of action set aside that transfers a subject property as a fraudulent conveyance. So when they brought the case, the plaintiff submitted evidence that the power of attorney did not grant the defendant gift-making authority. And the defendant improperly used the power of attorney to gift the subject property to himself. So this is one they file and say, it was a case of the plaintiff and defendant were brothers. And the person that granted the power of attorney was their half-brother. And so they obviously weren't getting along. One half-brother finds out that the property was deeded to by himself. The one brother deeded the property to himself under the power of attorney, and he didn't have authority. The court ruled against the Supreme Court. And again, in New York, Supreme Court is a trial court. So they found that the trial court was wrong in dismissing this. So again, it's a system working right. Someone bringing that special proceeding to say, hey, you shouldn't have done this. And they were able to move, it got sent back down, and we'll see what decision may be published. Next case, services rendered by an attorney. And this is the court's language, the mentally incapacitated client's agent under power of attorney. Their duties as power of attorney were more mechanical and administrative rather than legal in nature. And thus reasonable compensation for the attorney services under the power of attorney was 75% of the attorney's standard hourly rate of $350 an hour. So you got a 25% discount. And the court wasn't saying that they felt that the attorney had acted properly, they'd done a great service to this person. They said, but you're not acting as an attorney, you were acting as a power of attorney. You did help them, but you shouldn't have got $350 an hour. Still got quite a bit of money per hour, but they reduced it. So that's, they went into this whole concept of reasonable compensation. That's what the statute could say, but this is really not a lot of case law on how do you determine what's reasonable. And that's what they undertook in this particular case to do. This one was a legal malpractice action, and the defendants, who were the attorneys, tried to get a summary judgment, have the case dismissed, and it was denied. And what the court found was that the defendants, these attorneys, offered no competent evidence or an explanation as why they drafted an irrevocable trust in 2015 at the sole request of the decedent's niece, naming her the sole trustee and beneficiary, at the niece's request and not at the client's request. So the client was the power of the mere fact that the power of attorney permitted the agent to create an irrevocable trust was not controlling, and dismissal of legal malpractice claim was denied. So just because the niece had power of attorney, just because the power of attorney allowed her to create a trust as power of attorney, didn't mean it was the right thing to do. The attorneys hadn't taken the steps to actually verify that the person, their client, who is now deceased, lacked capacity, that was actually her wishes too. So they didn't have any evidence. So just again, that very interesting case where someone did go after the activities of the power of attorney by saying the attorneys committed malpractice. So interesting. Next one, another interesting case. We have a case where longtime companion, an agent, so someone acting as prince agent for their father, sues the estate of a longtime companion, and also that companion's power of attorney, and or their executor, I believe, at that stage, but her child and the child's significant other, I believe, too. The defendants actually moved to dismiss the case against them on the fact that the agent lacked standing as a POA, had power of attorney had been revoked. And what the court looked at and said, so they want to get rid of this case because they say, no, you can't bring this against us. The power of attorney was revoked by your father prior to his death. Or no, he was still alive. Revoked by your father. And they produced a writing to that effect, but could not prove that it had been properly delivered to the agent. So they didn't, this is something I mentioned before, if you want to revoke it, you've got to deliver it to the agent. So they couldn't prove that they delivered by agent. And they also had an email that a third party had received. And the court said, no, neither of these were sufficient to give the agent notice that the power of attorney was revoked. They were going to allow this case against the estate and the actors to go forward. So this was decided in September of last year, and there's no further follow-up to see what the outcome of the case was, but interesting that they weren't going to honor the revocation. And I think there was one more. Nope, I got them all. Okay. Recent case, one I'm working on right now, special proceeding for production of, we actually have two powers of attorney, a later power of attorney and an account of records. This is a case with a family member, is named the attorney in fact for mom, who had previously resided in her home. And we've just run into reluctance in receiving any documents. And we did file a special proceeding, and the claim from the beginning has been there's a a prior caregiver that has exploited the mom's assets and taken funds. But we still need the documents that since her activity as power of attorney. So we're due to have some documents delivered to us. We're also due to have depositions. We have an order on that. So it's one that we're actively working on. I don't know what's happened in this particular case, but we had to bring the case because we didn't get cooperation, we didn't get documentation. So that's how we ended up in the case. Where it will go from here, I'm not sure. I don't know if any bad activities have taken place by the family member, but we need to get the information so we can move forward. So I've given this presentation jointly with Melanie Carden from the DA's office, and I've kept a few slides in here for the criminal side. And what we generally talk about is that power of attorney is really no longer a license to steal. There is a variety of different potential charges, from theft to undue to illegal or improper use of their assets. So we've been using our EMDT and trainings that we've done for law enforcement. We've moved forward, in my opinion, over the last 25 years, leaps and bounds on our pursuing people that are misusing powers of attorney. Not only on that civil side I was just talking about with our cases, but in association with our enhanced multidisciplinary team and also with our district attorney's office and law enforcement pursuing these cases. In some of these things that Melanie's always mentioned, don't just look at bank accounts either. It may be personal possessions, and there might be cash and other assets in the home. Some of the other slides I wanted to keep is this might apply more, not just to law enforcement, but also to adult protective or anyone else. If you're assisting an individual, what are you looking for? What are we trying to establish? And we're not looking to step on law enforcement toes, but if you're in this job and you're working and assisting or talking with a client that may have been financially exploited, people you want to talk to. Victims, suspects, and this really for adult protective, we do talk to the suspect because they were probably a caregiver, other family members, neighbors, who else knows them, victim lawyer, bank employees. These are all things that people that might have more information about what's going on with this particular power of attorney. What do we want to look at? Like when I'm looking at these records, we do want to see the power of attorney. Credit reports. Have there been is the client willing to sign a release so we can get a credit report for them? Because that can give them a lot of information about whether there's credit cards that have been obtained on their behalf. Tax records that might show us other forms of income. Bank statements of not only our victim, but suspects. Are you able to do that? And that might involve law enforcement getting a grand jury subpoena. Those are things that they're going to look at. Adult protective, we might have under the banking law or social services law. We can get our clients' bank statements, but would really be looking at grand jury if you're looking at for suspects information. Surveillance footage at banks. If you act quickly, there might be documentation there. Other things to look at, medical records for the victims. And someone brought this question up earlier, is that can the lawyer that's signing the power of attorney and doctors, can they disagree on capacity and competency? For prosecution of power of attorney of theft using the power of attorney. If you have a capacity evaluation by a doctor that says on this date, this person no longer had capacity, and then you either have a power of attorney being signed thereafter, or that would be great evidence for them. Or if they no longer have capacity and there's money being not used for their benefit, is the power of attorney acting in their best interest? Are they acting pursuant to their wishes? So toxicology screens for victims, prescription records. We want to establish, is there some other reason that our client might be lacking capacity? But this, again, on the criminal side. Collaboration. This is stuff that we do work on. State Attorney General's office, they do a lot of identity theft and scams. They work on those. Melody Carden, she's actually the bureau chief of the Onondaga County District Attorney's Office Economic Fraud and Rackets Bureau. Referrals to Adult Protective Services, Vera House, the Elder Advocates for the, and also they are the hub for our enhanced multidisciplinary team. Internet crimes, you can report it on IC3, like for scams. I think you can use it for not just internet crimes. Bank suspicious activity reports, they have to keep a record of when they suspect suspicious activities. And FBI, recently, we've had actually FBI assisted on an EMDT case that they were involved in, and they have a forensic accountant that's based out of Syracuse that can look at these elder exploitation cases and power of attorney abuse cases too. We do have an Elder Justice Committee in Syracuse. I'm a co-chair of that, and we talk about cases. And if anyone's interested in, you can contact Lauren too if you want to become involved. We've been doing our meetings once a month, but they've been remote, and we'll continue remote for the immediate future. Hopefully we'll get back to in person. I mentioned the multidisciplinary team, and we do have a forensic accountant that we have access to through our EMDT, and it's been really critical. And I've had access to them to testify in guardianship matters. I've had access for them to testify in a matter I'm dealing with a trustee that's acting inappropriately. So it's been extremely helpful. And I think I'm making it in just under time, so I can have a couple questions.
Yes, we've had 4 questions come in throughout that I decided to reserve to the end, just kind of based on the topics. Quick logistical question regarding signatures. Can an agent sign on a different date than the person who appointed them?
So yes, they don't have to sign at the same time. And that happens a lot of times. They may be out of town, but the power of attorney is not valid until the agent actually signs.
Great, thank you. Next question is kind of a general question about the need for powers of attorney in general. If someone already has their child on all of their accounts, do they really need a power of attorney?
Maybe not. There's certain things that you say all my accounts, and then I'll say, well, how about that IRA that you have, or the life insurance policy? Because a lot of our clients, wealth in the United States, most of it's now looks like it's in retirement accounts. So you can't have a co-owner on a retirement account. You're not even your spouse. So something happens to you. So there's a lot of good reasons. Maybe your motor vehicle too. It might not be on that. So potentially no, but I wouldn't be so certain.
Definitely great points. General question about the rights of a power of attorney. Can a person with power of attorney stop people from visiting the principal, for example, in a nursing home or at a hospital, or stop people from going into the principal's home?
My opinion, no. If you read, and I don't have it right in front of me, the exact language, it talks about all other matters, but you're not standing in the person's place to say who should visit, and I don't see that as a valid use of the power of attorney. And I'm sorry, I could cite, but if you look through the statute, there's actually, it gives examples of which power, every power that is listed under the general power of attorney, it will go in and give you explicit examples. So it's worth reading and looking through the statute. It's, again, the general obligations law 5-15, it's that whole section, but there's a listing of each individual power and impeding family visits. And there's Peter Falk's law in the guardianship proceeding, because this is an issue that's come up in guardianship proceedings too. Now the court has the ability to say who will visit, who's allowed to visit, who's entitled to notice of death, who's entitled to notice when they were moved from a facility. That's within a guardianship proceeding. So, and that was Colombo. He had an issue with his family and they changed past the Peter Falk law for that. So that's in a guardianship proceeding.
I think this is the last question that we'll have time for. It was the last question I received. Does a financial institution have to provide transaction records to a monitor? How are they to verify the identity of the monitor when they do not have their signature notarized on the form?
Yeah, I don't, and I'm gonna guess a little, my understanding of the monitor is that they have the ability to monitor the client and make the request directly to the client. It's not an independent role for them with the bank. They can bring the special proceeding, which would allow them to get that court ordered, but that's not, I do not believe that they have that authority, and I'm guessing a little bit on that, but that's my understanding.
Great, thank you so much, Morgan. I have had a couple of questions. If I can send out the PowerPoint to everyone, and as long as I have your permission to do so, I can definitely get that out to everyone who attended today via email.
You can send that out, being mindful I had two, you know what I'll do is I had two mistakes that one was a numbering one and the other one was just that the change in the damages. And I'll just change those couple slides and then I'll get that to you and then you can send it out.
Perfect. Thank you so much. And thank you again so much for taking the time to share your expertise with us today. This was incredibly informative and we got a lot of great questions from everyone who attended today. So thank you all for coming. And again, Morgan, thank you so much for your time today. We really appreciate it.
Thank you for having me.
Thanks. Take care, everyone.